Good evening, everyone. Welcome this evening. I'm Walter Sterling, the Dean of St. John's College, Santa Fe. It's my pleasure to welcome you all tonight to our Dean's Lecture and Concert Series. And I want to say a special word of welcome to any family members that are here. It's Johnny Family Weekend, and it's great to bring that back in full this year. And we have a wonderful turnout, so welcome to parents and other family members who are here tonight, please. And I also want to mention, with Carter's permission, that if anybody is here with a copy of his book that you'd like to have signed, just let us know right at the start of the question period. You can come up or sit up front, and we'll take a couple minutes for that. O. Carter Snead is Professor of Law, Concurrent Professor of Political Science, and Director of the DeNicola Center for Ethics and Culture at the University of Notre Dame. Professor Snead is a leading expert on public bioethics, the governance of science, medicine, and biotechnology in the name of ethical goods. His research explores issues relating to neuroethics, enhancement, human embryo research, assisted reproduction, abortion, and end-of-life decision-making. He is the author of What It Means to Be Human, The Case for the Body in Public Bioethics, Harvard University Press, 2020. Which was named by the Wall Street Journal as one of the 10 best books of 2020. In his review for the same paper, Yuval Levin called it among the most important works of moral philosophy produced so far in this century. In May of 2022, it was listed in the New York Times as one of 10 books to understand the abortion debate in the United States. Snead and the book received the 2021 Expanded Reason Award, given by Francisco de Vitoria University in Madrid and the Joseph Ratzinger Benedict XVI Vatican Foundation. The book has been reviewed and discussed in numerous publications, academic journals, and media outlets. In addition to his scholarship and teaching, Snead has provided advice on the legal and public policy dimensions of bioethical questions to officials in all three branches of the US government and in several intergovernmental forums. Prior to joining the law faculty at Notre Dame, Snead served as general counsel to the President's Council on Bioethics, chaired by Dr. Leon Kass, himself a one-time tutor at St. John's in the early 1970s with his late wife, Amy. Professor Snead regularly serves as an expert witness on bioethical matters before Congress, state legislatures, and state and federal courts. Snead led the U.S. government delegation to the United Nations Education, Science, and Culture Organization, UNESCO, and served as its chief negotiator for the Universal Declaration on Bioethics and Human Rights, adopted in October 2005. He served as the U.S. government's permanent observer to the Council of Europe's Steering Committee on Bioethics. Professor Snead clerked for Judge Paul J. Kelly, Jr. of the U.S. Court of Appeals for the 10th Circuit, whose chambers are here in Santa Fe. He is an elected fellow of the Hastings Center, the oldest independent bioethics institute in the world. Snead graduated magna cum laude from Georgetown University Law School and, most importantly, graduated from St. John's College in Annapolis in 1996. Where he also met his wife, Lee Fitzpatrick Snead, Annapolis 98. Before I say a personal word, I want to just talk about our format. Carter's going to talk for 45 minutes to an hour, then we'll take about a 10-minute break for refreshments, then we'll return to this space for the question period. So we hope many of you will rejoin us for conversation. So finally, just a personal note, Carter and I first met as undergraduates in Annapolis, almost certainly on the football field or basketball court. And though connected by mutual friends, we did not see each other for at least 20 years. When next we met, I was attending the Fall Conference, that's what it's called, at the DeNicola Center in 2016. I've come to believe that conference is one of the most important ethics and humanities conferences in the country, held annually, always attended by some Johnny graduates and former or current faculty of the college. Also, I want to say, I venture to say, that the two most widely read and commented on nonfiction books by Johnnies anywhere in the last decade have been Carter's book that underlies today's talk and our colleague and fellow Johnny Zena Hitz's magnificent book, Lost in Thought. As one will learn from Ms. Hitz's acknowledgement, that book stemmed from a talk at the Fall Conference and then was substantially written over a semester as a fellow at the DeNicola Center. This is just one example of the many ways Carter continues to support St. John's and fellow Johnnies. And I am very happy not only to count him as a friend, but also as a friend to the college, and very happy we have him here today to join us in conversation. Professor Snead's talk this evening shares the title of his book, What It Means to Be Human, The Case for the Body in Public Bioethics. Please join me in welcoming Carter Snead.
Thank you so much, Walter. I can't tell you what a great treat and pleasure and honor it is to speak at St. John's College. When I was working at the President's Council in Bioethics, Leon Cass, who has a PhD in molecular biology from Harvard and an MD from the University of Chicago, said he learned more about science as a tutor in a freshman lab at St. John's College than he did at any other place in his formal education. And I was like, wow, that's crazy. He was in Mr. Maestrellis' class. If you guys know Mr. Maestrellis, he retired from Annapolis. But the truth of the matter is the most important and influential place community of learning that I've ever participated in and have had the blessing of participating is St. John's College. And so it is so meaningful for me to be here with you this evening, and I can see all the Johnnies and some tutors and people from the community, and it's hard to maintain my composure. I'm so excited by this. Anyway, and as Walter said, I mean, it's important to me to support the college and its students and its faculty. And any of you students in the room who are thinking about going to law school, I'm the chair of the Faculty Committee on Admissions at the University of Notre Dame. So please, so I have a little bit of influence. So let me. I want as many Johnnies as we can fit at Notre Dame Law School. Okay. So, and Walter, thank you for that generous. And one final point about Walter. Walter is, I mean, you all, I'm sure you understand this, but I have to say it anyway, how blessed this institution is to have such an extraordinary person as dean of this college. Very few people in academic life combine the kind of deep learning, real extraordinary judgment, prudential judgment, as well as deep humanity and goodness as Dean Sterling. So I'm so pleased that he's the steward of the academic dimension of this college. So, and thank you for inviting me. Okay, so I'm going to talk about the themes of the book this evening, the fundamental claims of the book. There are two principal claims of the book. One is a methodological claim, and the other is a substantive claim. The substantive claim emerges from the application of the methodological claim. The methodological claim is that the richest and most potent method of analyzing matters of public bioethics, and I'll give you some more detail on what I mean when I say public bioethics, is through what I describe in the book as an inductive anthropological inquiry. Now that sounds highfalutin and hyper-technical. It's not. When I describe what that means, it'll become immediately apparent to you what I'm talking about and how it works. It's inductive in the sense that it takes the law or a public policy under consideration as you find it. So it's inductive. You don't bring to bear in your analysis some principles that you apply to the legal landscape as it exists. You take the landscape and you ask questions about it. And the questions that I think the most important question to ask about any legal matter, any public policy matter, is what assumptions lie at the core of this doctrine or principle or policy. What assumptions are there about what it means to be a human being and flourish as a human being? Questions about human identity and human thriving. And I'll explain why I think this matters to the legal questions in the public bioethics context in particular. But I think that that's the most potent way into all of these questions. And the substantive claims of the book emerge from my applying that inductive anthropological inquiry to certain areas of American public bioethics, what I call the vital conflicts of American public bioethics. And I'll say a little bit more about that in a minute. But what happens when I look at those concrete areas of law and policy and ask the question, what vision of the person anchors and animates the legal doctrines and principles and policies, what comes to the surface is a particular version of human identity and human flourishing that is, it's true in certain limited respects and important in certain limited respects, but it's incomplete in deeply problematic ways. It's a vision of human personhood and flourishing that closely tracks what sociologist Robert Bellah, in his 1985 book, Habits of the Heart, first coined the phrase as expressive individualism. And that concept has been deepened and explored by philosophers like Charles Taylor and Alistair McIntyre and others, and Michael Sandel, and I'll be talking about them in the course of my remarks this evening. But the problem is, once you identify this particular anthropological set of premises, which I will call expressive individualism, it becomes immediately clear that this is not a vision that is sufficient to grapple with, it can't even make sense even, of the lived reality of human embodiment. The fact that we don't just have bodies, but the claim that I make is that we are bodies. We are enlivened bodies. We are a dynamic union of mind and body. And we negotiate the world, experience ourselves, experience one another and the world around us as living and dying bodies. And that matters a lot to the core, to everything, but it especially matters to the questions of public bioethics. And any anthropological set of premises that can't make sense of embodiment can't make sense of the vexed questions and complexities and issues that arise in this particular field. And in particular, the aspects of human embodiment, the aspects of our individual and shared lives as fragile, vulnerable bodies in time, corruptible bodies in time, they're actually, I think, insights that can be gleaned from those physical realities of vulnerability that lead to normative concepts and normative, I would argue, even obligations or privileges that we have that are not in the mere domain of consent and a contractarian frame. Reciprocal indebtedness, our subjectivity, our subjection to natural limits. All of that situates us in a kind of relationship to one another that has real import, I think, for those whose job it is, and it's all of our jobs living in a representative democracy, to build laws and policies that are just and humane and wise. So, how am I going to do this? So, the method that I'm going to use to try to, or the framework that I'm going to use to try to make these claims this evening are as follows. First of all, I'm going to give you a very brief working definition of what I mean by public bioethics. A lot of people haven't heard that expression. A lot of people have heard the word bioethics as a kind of domain of inquiry involving the ethical questions that arise from advances in biomedical science and biotechnology. That's not what I'm talking about. It's related to what I'm talking about. That's not what I'm talking about. I'll be more specific in a moment. Then I will sort of sketch out why I think this anthropological analysis is such a useful tool in understanding legal principles, legal doctrines, legal policies, and you know, just even court decisions, statutes, regulations, ordinances. Why I think this is such a potent way of understanding these different sources of authority. I'll give you some more detail on that. Then I'll dive a little bit more deeply into what I mean by expressive individualism and explain why I think it's an incomplete conception of the self that is, to borrow a phrase from my colleague at Notre Dame, Alistair McIntyre, it's forgetful of the body. And that's one of the key problems with this in the sources of incompleteness of this anthropology. And then I will conclude by sketching out a very sort of broad brush account of what I think must be done in order to save the anthropological premises at the core of laws and policies in the domain of public bioethics, a kind of anthropological corrective that begins with remembering the body, taking seriously our embodiment, and sketching out what kind of concrete entailments there are for that. And then I'll wrap up and we can have some cocktails and then we can come and talk some more. Okay, so public bioethics. Public bioethics is the governance of science, medicine, and biotechnology in the name of ethical goods. Okay? It is not simply intellectual inquiry, it's not simply disputation, it is actually the point at which those who have the authority to govern, which is, again, in the deepest sense, us, but if you're talking about the Supreme Court of the United States, you're talking about Congress, you're talking about the state legislature, you're talking about administrative agencies, and in some cases you're even talking about private parties whose cases make up the common law in different areas, and that's especially true in the context of malpractice, medical malpractice, and a lot of healthcare law. It is the point at which the law comes into contact with these ethical questions, and the law governs according to certain kinds of normative propositions regarding these vexed and complicated areas. But the thing that is most important for present purposes about public bioethics is that it is fundamentally, I believe, concerned with human vulnerability, dependence, frailty, and finitude. It's about things like procreation and pregnancy and babies and wasting illnesses and devastating injuries and desperate enrollees in clinical trials, fearful patients, the disabled, the elderly, the dying, and even the dead. Put another way, public bioethics is most deeply about the meaning and consequences of human embodiment, the fact that we experience ourselves, one another, and the world around us in and as living and dying bodies. So, public bioethics itself, most scholars and commentators identify the birth of American public bioethics, and there's disagreement, as there always is in scholarship, but the narrative that I think makes the most sense and that resonates most with me, and the narrative that I sketch out in the book, is that American public bioethics began in reaction to certain kinds of very high-profile scandals and controversies in the late 60s and the early 1970s. That is where most scholars sort of locate the beginning of this unique area of law and public policy. Again, there's dispute around the edges about that. There are different ways to date it, but I think that for our purposes, the most thoughtful way of doing it is to say there were basically three events that gave rise to American public bioethics, that shed light on the nature of this area of law and policy in a special way. And I should say that public bioethics, as a field of law and policy, has traditionally been, with very few exceptions, reactive. It's a reactive form of governance, and usually what happens, you have a scandal or some high-profile event, and then the political branches of government, usually, sometimes the judicial branches of government, but the political branches of government usually react in some way, try to take some action, fact-finding, hearings are convened, and then some kind of official state action is undertaken. And there are three signal events that I focus on in the book as giving rise to American public bioethics as we know it today, and I think tell us something deep and important about the nature of this area of the law. And those three events are, and you can see up here on the screen, the man on the far left is a guy named Henry Beecher. Henry K. Beecher was an anesthesiologist at Harvard University, and he was a great student of the ethical abuses by the doctors in concentration camps during the Holocaust. And you may know that there were a series of trials after the war was concluded called the Nuremberg trials, and they were divided up into different proceedings, and one of the trials was referred to as the doctor's trial, and it was an extraordinary moment, and Beecher was a great student of this, and one of the arguments made by the, well, there were two interesting arguments for our purposes made by the defendants in the Nuremberg trial, all of whom were found guilty, some of whom were executed. And these doctors who subjected the people who were being subdued in these concentration camps to unbelievably violent, grotesque, exploitative, and extractive forms of experimentation that almost always resulted in the death of the human subject involved. And when they were confronted about it, these Nazi doctors said, well, look, one, we didn't put them in concentration camps, and they were going to die anyway. And we were just trying to salvage some goodness, some good aspect from this tragic situation. Now, of course, the court rejected that. They said, no, you didn't merely try to salvage something from a tragic situation. You actually commandeered a tragic situation, made the object of the suffering and death of these individuals part of your own goals, and therefore we're not persuaded by that claim that we didn't do anything worse to these folks than was going to happen to them anyway. But the second argument, which really captured Beecher's attention, was they said, you know, you Americans, you're so sanctimonious about this, but you don't have any ethical guidelines for human subject research either. And in fact, the very first code of ethics for human subjects research was in 1946 by the American Medical Association in response to the Nuremberg proceedings. So it wasn't false what they said about our own lack of at least codified standards to protect the well-being of subjects of research, human subjects of research. So Beecher said, I'm going to take a look at what goes on in the United States. And so he studied the question, and he identified 22 studies undertaken by the most elite and eminent research institutions in the world. Harvard University was involved, the NIH was involved, the Defense Department was involved, esteemed researchers, research studies that had been published in the most elite journals, the New England Journal of Medicine, the Journal of the American Medical Association, They're peer-reviewed. The methods and conclusions had been evaluated by peer reviewers, and they'd signed off, and these had been published. 22 studies. And in all 22 studies, except for 2, there was not a single mention of the word consent or any kind of effort to secure the consent of these highly vulnerable populations of human subjects who were being exploited and in some cases deceived, and in some cases endangered. Some people died as a result of these interventions. And in only 2 instances was there a meaningful effort to secure informed consent. And he published his results in a study, in a paper in the New England Journal of Medicine, 1966, with a very sort of understated title, Ethics and Clinical Research. And it sent shockwaves to the research community, because just to give you a few examples of what these researchers did, there is a place on Staten Island, there was a school in Staten Island called the Willowbrook School for cognitively disabled children. And it was a very dingy, badly run institution, and the conditions in which these kids were held were shocking to the conscience. And hepatitis was a serious problem in this institution. And so these researchers went into Willowbrook, and they deliberately infected children with hepatitis and studied the natural progress of the disease. And when confronted about it, said, well, they probably would have gotten hepatitis anyway. We didn't create these tragic situations. We're just trying to vindicate some positive good from it. Now, that sounded to Beecher like arguments that were made by the defendants at the Nuremberg trials, a kind of sophistry about coming into a circumstance of deprivation and making it your own and harvesting it for your own purposes. So Beecher, another example, at the New York Jewish Chronic Disease Hospital, patients with dementia were injected with live cancer cells. Certain kinds of proven treatments were withheld from enlisted Army servicemen, some of whom died as a result, who Beecher found and others found that they would not have died had they not had this efficacious treatment withheld from them. So it's serious violations, ethical violations, sent shockwaves through the American public and certainly the research community. The second scandal, represented by the middle image that you see here, which you may be familiar with, came to light in 1972. So Beecher's was 1966. 1972, in an article called Human Guinea Pigs, Syphilis Patients Died Untreated by Gene Heller in the Washington Daily News, later published in the Washington Star also, described what were meant to be a natural history experiment of the progress of untreated syphilis. And what researchers, not researchers supported by the government, but literally government employees from the U.S. Government agency, public health agency, went into Macon County, Alabama in 1932, into Tuskegee, which at the time had the highest incidence of syphilis anywhere in the country. Okay, it's a sexually transmitted disease that has ravaging effects on the bodies and lives of its victims. And they went into this community of poor African American sharecroppers, people who were already beset by poverty and racism and crushing socioeconomic circumstances. And they went into that community and they said, we're just going to study. We're going to take 600 people, 300 have syphilis, 300 in a control group. We're going to study the progress of this disease untreated in this community. And they systematically deceived these poor people for 40 years. It was supposed to be a 6-month study. It lasted for 40 years. And they told the community there that we're just testing you for bad blood. They didn't explain what they meant by that. They gave people a pittance. They gave them a little money for lunch. They promised them money for funeral expenses, and they subjected them to spinal taps. They subjected, and again, and most shocking of all, in the middle of the 1940s, when antibiotics, when penicillin became part of the standard of care for treating syphilis, they did not tell them about it. They didn't tell them they had syphilis, and it was reported, I think credibly, that they colluded with the local health authorities in Tuskegee to prevent them from getting health care. Okay? It devastated families, the disease ravaged through the community, and then when, in 1972, a low-level researcher at the U.S. Public Health Service in the venereal disease section saw that this was going on, raised the issue to his superiors. They ignored him, so he went to the press, who reported on this scandal, and then there was a $10 million settlement and a huge uproar in the American public, and ultimately apologies were issued by the government, the U.S. government itself, but not before many lives were destroyed by the disease. And when asked about it, representative of the U.S. Public Health Service said, well, we didn't do anything to these folks that wouldn't have happened anyway. Given the racism, the crushing poverty, they wouldn't have had access to these drugs anyway, and all we did was watch the progress of the disease. We didn't make their circumstances worse. I think that's actually factually false. I think they deceived them and prevented them actively from getting care, but even if they hadn't done that, it would have been gravely unethical to behave as they did. Around the very same time, in 1973, there was an article written in the Washington Post, front page, three front page articles in the Washington Post over a period of weeks, about a series of a debate at NIH as to whether or not they should fund research in which American researchers travel to Europe, Scandinavia, to where abortion is performed at the time by a process called hysterotomy. Basically, it was just performing a C-section, removing the fetus and allowing it to expire. But the thing that was interesting to these researchers about it was you had a living, intact, no longer a fetus, but a neonate, a newborn child who was no longer in utero, ex utero, right? In some cases still attached to her mother by their umbilical cord, and these scientists wanted to perform experiments on them, even experiments that extended their lives for several hours, to test equipment, to test different kinds of diagnostic techniques, and to study brain metabolism, to study the transmission of certain kinds of diseases. And again, what they were doing is they were going to where these abortions were going to be taking place. So it's undisputed that the newborns were marked for death. That is, they were going to die by design because it was an abortion. But they said, we're gonna lay hold of these living organisms, these living neonates, these living newborns outside of the body, and experiment on them. In some cases, sustain their life while the experiment's going on. In some cases, the experiment itself is the thing that caused their death in an immediate sense. And this also created a great deal of scandal, especially among the Kennedy family. Eunice Shriver, who is a sister of John F. Kennedy and Robert Kennedy and Edward Kennedy, she found out about this and told her brother about it, and Senator Kennedy convened hearings. And again, this is the pattern, right? You have a scandal, you have a reaction, and the reaction to these three sort of signal scandals were hearings convened in the early 1970s by Senator Edward Kennedy. There were 11 days of hearings between 1973 and 1974, examining all kinds of questions involving the use of new biotechnologies, gene therapies, genetic interventions, sort of early conversations about human cloning, issues involving neuropharmacological manipulation of behavior, as well as they had a whole session on, I think they called it outrageous research abuses, and Tuskegee fell into that category, and a lot of the Beecher stuff fell into that category. And so they held hearings, and these hearings, for those of you who are not familiar, they invite testimony from experts, and they do fact gathering. That's the idea is this committee does fact gathering. And in fact, this wasn't the first hearing on American public bioethics. In fact, 1968, Senator Walter Mondale, on the occasion of the invention of the artificial heart, convened a series of hearings and wanted to create certain kinds of federal systems, regulatory schemes to put in place oversight for different kinds of human subjects research, and it kind of foundered, went nowhere. But Senator Kennedy, he actually was successful in creating the momentum for a federal statute, which was called the National Research Act of 1974. And the National Research Act of 1974 did several things. First of all, it imposed a moratorium that is a temporary halt on research involving live neonates who had been aborted, right? So that is the fetus has been removed from the womb and is now out of the womb ex utero, so it's no longer a fetus but rather a neonate or a newborn. There was a kind of moratorium on the funding of that research, not on the practice itself, but on the funding itself. And then it also put in place the sort of the beginning structures for what became federal protections of federal regulations protecting human subjects in biomedical research. And then the other thing that it did, which is very interesting, it created by statute a national commission of 11 experts, 5 of whom, but no more than 5 of whom, had to be researchers engaged in biomedical research involving human subjects, and these to grapple with questions. And they were tasked with identifying the basic principles of ethics that are necessary to govern research involving human subjects. And the statute said that their recommendations would be presumptively binding on the federal government. They would go to the Secretary of what was called then the Health, Education, and Welfare. It's now called the Secretary of Health and Human Services. And the Secretary would have to implement their recommendations or make a public pronouncement as to why he or she wasn't doing that. So that's a lot of power for the first bioethics commission that was ever created, and it was created in 1974. So you take these 3 signal examples, and they tell you something, I think, important about American public bioethics. First of all, as a field of law and policy. First of all, it's enormously complicated, right? It's very, very complex. Not only are the biomedical interventions complex, not only is the science hard, but it's complex in a way that is morally complicated because it seamlessly integrates great goods with serious and grave risks. Every single one of those researchers in Tuskegee, I would charitably say, and those that Beecher described and those that went to Scandinavia, believed in their core that they were doing something good for humankind because they were developing generalizable knowledge that would be used to relieve man's estate, to borrow a phrase from one of the authors of the program, Francis Bacon. They were doing something that was for the greater good, and they were engaged in and maybe entangled in something that was ethically questionable, but it was for a greater good. And not only were their motives, integrated, good motives integrated with sort of bad deeds, but also all the techniques that are under discussion in these areas are by themselves, as are all scientific interventions, neutral. They're just tools. They're just things that can do things, and therefore the question of motive, the question of application, the question of consequences become a very complex array of things that we have to disentangle in order to do any sort of ethical analysis of it. And that's very much true of this area of the law, American public bioethics. Secondly, and you just noticed it from the very conversation about these things, is it's unbelievably contested. People disagree bitterly about what norms should govern in these areas. They disagree bitterly about what we should do in these contexts because these questions implicate the nature, meaning, and consequences of things that are at the core of what we are as human beings: birth and life and death and procreation and parenthood and childhood and race and poverty and illness and scientific freedom and autonomy and dignity, equality, and even justice. These are hard questions. Public bioethics squarely and unavoidably poses the questions of who are we and what do we owe to one another, and that's something about which people very bitterly disagree in sometimes acrimonious terms. We see that more and more all the time. Third, I would say the notable thing that surfaces from these examples is that public bioethics involves what I describe as vital conflicts, frequently zero-sum matters of life and death. Sometimes they involve the contours and boundaries of the moral and legal community and the very vulnerability of the people, the children at Willowbrook, the folks suffering from senile dementia in the Jewish Chronic Disease Hospital, the people of Tuskegee, those newborns who were being experimented on in Scandinavia. Their very vulnerability emerged from the fact that they existed in a kind of liminal state regarding the contours and boundaries of the moral and legal community. And people disagree about where those boundaries should be. And that, again, is a central question in public bioethics. And then the fourth thing that's interesting about those examples is that one of the reactive moves that those in government make is to try to seek refuge in the good of autonomy, try to seek refuge in the principle of self-determination or freedom. They say, okay, look, we're a pluralistic country. People disagree about fundamental things. You're confronted with these shocking scandals, and you say, well, the most important ethical principle that we can repair to try to protect ourselves and others is the good of autonomy, informed consent, empowering people to say no to circumstances in which they are victims or potential victims of exploitation. But the problem is, when you're dealing with certain kinds of vulnerable populations, the problem is not the lack of, the problem isn't solved by trying to empower individuals to make their own decisions. The children at Willowbrook couldn't make use of autonomy, right? The children at Willowbrook were cognitively disabled children. They couldn't, autonomy was an unintelligible concept vis-a-vis their circumstance, except by proxy decision making, and that's not autonomy, right? That's another person making a decision on a person's behalf that usually that they think is in their best interests, right? So a lot of these questions, autonomy doesn't help you with a lot of these. A lot of the people that were in the diminished conditions that were described in the other Beecher examples were prisoners, people whose autonomy was irretrievably diminished by virtue of their circumstances. Enlisted servicemen who were subject to the chain of command and had greatly diminished autonomy. The autonomy of the folks in Tuskegee was diminished by things that those U.S. Public Health Service folks couldn't have fixed. The sort of institutional racism and poverty and cultural pathologies that beset that community. That autonomy is not a key that will solve that problem. Something more is needed. Which isn't to say that autonomy is not important, because of course it's important. So from that, the array of issues, and this is just a very small sample of the issues of American public bio. The three issues that I take up in the book, which I'm not going to be talking about in a concrete way this evening, are the legal contexts, right? The legal context of abortion, the legal context of assisted reproductive technology, and the legal landscape and context of end-of-life decision-making, including both the termination of life-sustaining measures in a clinical context, or assisted suicide and euthanasia, right? And again, the book is also, by the way, about law. It's not about individual decision-making, except insofar as it's shaped by law and policy, which it is, and I'll say more about that in a second. But it's not a claim that the questions that I ask and the conclusions that I draw involving the anthropological premises are not about people and the visions of human identity and flourishing that they have when they make individual decisions in their lives. It's about what the law assumes persons are and what human flourishing is. And in fact, the problems that I identify, I think, largely result from an asymmetry between the lived reality of personhood in those contexts and what the law mistakenly assumes and projects onto those clinical contexts, okay? So let me say one quick thing about law. Frequently you will hear, now Johnnies don't say this because they are too sophisticated, but you hear some people say sometimes, we should keep law and morality and ethics completely separated from one another. You can't legislate morality, you can't, and that, if you understand what law is at its core and what it does, that's not an intelligible claim. Every single legal proposition that there is rooted in a particular good to be pursued or particular harm to be avoided. Law is irreducibly normative. Otherwise, it would be arbitrary. Everything, including something as simple as like a speed limit, is a culmination, usually, of a debate about a bunch of competing goods, about efficiency and commerce and safety and environmental considerations and congestion, and the culmination of that ends up with the number on the sign, which is codified as an ordinance that you have to obey or you will be punished. That's a normative proposition, or it's the culmination. That codified rule is the culmination of normative deliberation. That's true of every single law that there is. So there's no separating law from judgments about ethics and principles like freedom and justice and equality. And so law is irreducibly normative. That's the first point I would make. And by the way, law is unbelievably fine-grained in expressing normative propositions. It's not simply a binary yes or no. Law can prohibit things with the strongest power the state has, the criminal law, to punish and deter. It can incentivize things through federal funding or state funding to try to incentivize and to signal that this is a worthy endeavor and that we should support it. But the truth of the matter is that there's a wide space between those 2 points of active encouragement and negative injunction, and that includes things like silence, right? Now, in our system, law, silence usually means you're permitted to do the thing that you wish. But then there's data collection, there's surveillance, there's licensure and certification. There are things like so prohibition with exceptions. There is permission with licensure. I mean, so it's a very fine-grained array of approaches that one can take, and the law speaks in different ways. And what the law does, on the one hand, is a reflective function, and it's always a weird thing to quote Oliver Wendell Holmes for bioethical wisdom, since he was the author of one of the most notorious bioethics decisions of all time, Buck v. Bell, in which he affirmed the constitutionality of a certain program of coercive sterilization and said 3 generations of imbeciles is enough. He was not, I think, a paragon of bioethical wisdom, but he was right, as one can be, in his proposition that the law reflects the goods that people hold dear and the harms they seek to avoid. Law is the witness and the external deposit of our moral life. So if you want to know something about what a polity cares about, look at the law. What do they care about? What are they afraid of? What do they value? What are they indifferent to or ambivalent about? What does the law say? That's a valuable point to gather important information about a given community. And law, so that has a reflective function, but it also has a pedagogical function, a constructive function. People, for better or worse, take their bearings and their attitudes about goods and harms and things like justice and equality and freedom from what the law says. And Louis Brandeis, after a fashion, described, talking about government, but it's true of law also, is the omnipresent teacher. So law is pedagogically extremely important in that way as well. So now, why is anthropology the key to understanding law and policy? Well, Walker Percy, one of my favorite novelists, said, everyone has an anthropology. There's no not having one. If a person says he does not or she does not, all they are saying is that his or her anthropology is implicit, a set of assumptions that he has not thought to call into question. And that's true of law as well. Why is that? Because law, at its core, is about and for the protection and flourishing of persons. That's what it's for. Law is, as it functions, it is for the protection and flourishing of persons. So therefore, it unavoidably rests on usually undeclared conceptions of human identity. And that is why, in a nutshell, I think the richest way into the question of these issues is through asking who and what does the law assume persons to be. And this is not the question, by the way, of who counts as a person. That's a related issue. But I'm saying you and I, you and me, what does the law think we are in its effort to protect us and to promote our flourishing? What does it assume about us in doing that? And when you ask the question about who the law assumes we are and what we owe to each other in these areas, these vital conflicts of American public bioethics, what I see, and I think it's problematic, is this concept of expressive individualism. And I won't get into it now, there's not time, but as Johnny's, I probably enjoy the intellectual genealogy of expressive individualism. I look to Charles Taylor and others, and there's this interesting debates and typologies of different individualisms. They talk about Hobbes and Locke and Smith and Tocqueville, and then there's this very interesting genealogy that Charles Taylor sketches through, beginning with Rousseau, and then through the Romantic era writers and artists of the 18th and 19th centuries, which then becomes manifest and translated into a more outside the domain of the arts into the normal polity around the time of the sexual revolution, the 60s and 70s. Robert Belloc studied this as a social scientist, did an interesting study in his book, Habits of the Heart. I'm not going to talk about that, but it's worth, maybe we can talk about it in the question period if you want to, but it's I think I'm a Johnny, and so this was really part of my favorite part of writing the book. And as a Johnny, I have to include something like this, which is to say, I think one of the most pristine examples of expressive individualism you find in Milton's Paradise Lost. And this is Lucifer talking to the fallen angels, denying their creaturely status. When this creation was, when were we created, they're asking. Remembers thou thy making while the Maker gave thee being? We know no time when we were not as now. No, none before us, self-begot, self-raised, by our own quickening power, when fatal course had circled his full orb, the birth mature of this, our native heaven, ethereal sons, our puissance, our power is our own right hand shall teach us highest deeds by proof to try who is our equal. So that's expressive individualism. The fundamental unit of reality in expressive individualism is the isolated, unencumbered, atomized individual self, shorn of all attachments, shorn of all connections. The thing that defines you, let's start with the fact that you are a numerical unit. You are one, okay? We don't define you by your relationships. We don't define you by the web of connections that you have. We don't define you by your traditions, even in a negative way. It's the atomized individual self that is the fundamental unit of reality. And it's not just the self, it is the will. It is the mind that defines you as a fundamental, as your fundamental essence. You have a will, that's you have a mind, that's you, and you have a body that is instrumental. So it's dualistic in this way. Persons are defined as individual choosers and consumers, and human flourishing is defined as the pursuit of projects of one's own construction. The imperative is to live according to your own originality. Flourishing is the inward turn to listen to the deepest sentiments of yourself, to find your authentic truth, to find the thing that is definitive for you. That's morally authoritative. That is substantively authoritative. That discovery and then the expression of that discovery, the formulation of future directed plans, the pursuit of those plans, wielding the instrument of your body and relationships with other people and maybe the natural world, that's what flourishing is in the context of expressive individualism. It is anti-teleological, meaning, you know what it means because you're Johnny's, but it means external givens are not normative. The givens of your body, the givens of nature, the observable givens of the world around us are not normative. The only thing that is definitive and normative is the unique and original inner voice, the inner voice that comes from within. There are no unchosen obligations or constitutive attachments within this worldview. The only source of binding authority is agreement. The only source of binding is free and full consent, and that means that personal relationships are also instrumental and transactional. And persons are isolated. They can come together in collaboration to pursue mutually beneficial future directed plans, but the moment that is no longer mutually beneficial, they break apart. And sometimes, maybe frequently, you encounter other atomized wills as adversaries. And you have to overbear those wills in the pursuit of your goals. And as far as ethics is concerned, it immediately becomes flattened and reduced to the concepts of autonomy, the highest good to which all others are subordinated. And injustice is reframed and reconceived as constraint on freedom to pursue the projects of your own choosing. And the role of government and social life is to remove those constraints, public constraints, private constraints, maybe even natural constraints, and otherwise provide the conditions for the assertion of the unencumbered individual self. Now, in some ways, this is a very sexy vision, right? This is a very attractive idea. The solitary individual bestriding his or her environment, bending it to his will or her will, blazing maybe an unprecedented trail, perhaps a countercultural trail that comes from inside. It kind of is sort of this notion of authenticity and originality. And you can see why it would appeal to romantic poets like Emerson and Hawthorne and Whitman and others. And it's attractive in a certain sense. But the problem with it is that it doesn't actually describe the fundamental reality of the arc of human life. It only applies, that freedom, that flourishing is only possible for an unbelievably narrow sliver of the human population, the most privileged among us, and even among them for the briefest period of time. Because we begin our lives not as disembodied wills seeking to impose our purposes on our environment around us. We begin our lives as profoundly vulnerable and dependent babies, and even before that, in the womb. You begin your life in a state of total dependency and vulnerability because of our embodied situation, right? And then we gradually, if all things go as well as they could possibly go, follow a gentle arc upward to the height of our powers, where we stay for a moment, and then we immediately begin a gentle, God willing, arc down back into total dependence again. Okay? Expressive individualism captures something, and it's true, right? We are free, or we We are particular, like we are individuated. That's important. Those are important truths, and freedom is important, right? But it's not the only thing. And it's only useful to us at a pretty narrow moment in our life. And if you look around the community, there are people around us, our brothers and sisters and friends and neighbors, who never are able to exercise that freedom of the unencumbered will because of conditions of profound dependency, because perhaps of a disability or cognitive impairment or social circumstances, who knows. But it's just, expressive individualism is not, it can't capture the full truth of who we are in light of the arc of our lives, which is a function of our existence as fragile, corruptible, embodied beings in time. Lived embodied reality is not about the imposition of will. It's about mutual dependence. It's about vulnerability. It's about natural limits. And Alistair McIntyre says, because of that arc, all human beings exist on a scale of disability. And so what you need as an embodied being, and what communities of embodied beings need, is not the freedom of the unencumbered will. What you need are what McIntyre calls networks of unconditional and uncalculated giving and graceful receiving. You need people, networks of people who are willing to make your good their good without seeking anything in return. You need it for your basic survival. None of us would be here unless someone in our lives had done that for us, probably our parents. But you also need it, and this is a normative claim that I'm making, you need it for human flourishing, because what I argue is human flourishing is not about imposing your will, it's about taking care of each other. Human flourishing is becoming what we're meant to be, namely those who can make the good of others our own good without seeking anything in return. Human beings, put more concisely, are made for love and friendship by virtue of our embodiment. That's the core argument of the book. And expressive individualism misses all of that because it can't recognize the unchosen claims that the weak have on us, our children, the disabled, the elderly, the poor, refugees, the prisoner. There are people who have claims on us that we don't choose, that it's not a function of our consent. There are people by virtue that adhere in certain kinds of relationships. Parents don't take care of children because they have a contract to take care of the children. It's because that's what it means to be a parent. A child doesn't have to earn the right to be cared for by his or her parents. There are different ways of taking care of children, right? But you don't have to earn that right. That's an unearned privilege that inheres in the relationship itself. And if you think about a world in which everything is a transaction, everything is about contracts, everything is about bargain for exchange, meeting of the minds, et cetera, you end up with what Bertrand Juvenel called a chartered libertarianism for the strong. And it leads to loneliness and dislocation and alienation. There's no constitutive relationship possible. If you really believe the fundamental truth is inside you and no one can know it but you, and no one can know you're good but you can express it, but they can't really, it's not ever fully transparent. It's death-haunted, as Solzhenitsyn says. Once you consider yourself to be the center of all things, your death is the extinction of the entire universe at a stroke. And as Bella found in his social science findings, and as Tocqueville worried about with a different kind of individualism, it wasn't the same thing, was a kind of erosion of social and familial ties, focusing on what separates us rather than what binds us together. So what do? How do we fix this? As I said, expressive individualism, there's something true about it and important about it that we need to take seriously, but we have to augment that by what I in the book describe as remembering the body and developing the goods and practices and virtues for lived embodied reality. We need to recognize and learn to participate in these networks of uncalculated giving and graceful receiving that are necessary to sustain and flourish in our shared embodied lives. We need to become the kind of person who can make the good of others our own good. We have to learn to see the vulnerable who have claims on us through the practice of memory of our own vulnerability, and our moral imagination, seeing through what Mother Teresa sometimes described as the disturbing disguise of poverty, to see your brothers and sisters who have a claim on you whether you want them to or not, or see people that you can make requests of and invoke unearned privileges from, regardless of the nature of the reality of contractarian ways of seeing the world. McIntyre says, it matters that those who are no longer children recognize in children what they once were. Those who are not yet disabled by age recognize in the old what they are moving towards becoming, and those who are not ill or injured recognize in the ill and injured what they often have been and will be and always may be. So what are the virtues? How do we build these networks of uncalculated giving and graceful receiving? Well, I think it has to do with the practicing of what McIntyre calls the virtues of acknowledged dependence. And the virtues that he describes of uncalculated giving are the virtues of just generosity, giving to others in proportion to their need, without a calculating sort of self-interested way. Hospitality, welcoming the other, welcoming the stranger, because they are a stranger, because they are other. The virtue of misericordia, which means making the suffering of another person your suffering. And in the medical context, this matters a lot. You're talking about the imperative to heal or to comfort, or even in the absence of the possibility of healing and comfort, accompaniment, mere accompaniment with those who are suffering. And then the flip side are the virtues of graceful receiving. And chief among those is gratitude. The idea that you recognize that I didn't really earn any of this. I am the product of the sustained work of other people, people I've never seen before, obviously family and community, but also stretching backwards in time to those who built this civilization and this culture. I don't deserve really anything that I have. Everything is a gift, which should engender humility, which is another virtue of acknowledged dependence, and an ethic of giftedness to say, okay, well, if I have things, and I'm fortunate, I have things that I don't deserve, and I look around my community and I see there are people that these gifts are not distributed equally, I have an obligation, I have an imperative to go to those who are not as gifted and have not received the gifts that I've received, and to help care for them and to take care of them. That's a kind of obligation that I have that emerges from that awareness and becoming alive to gratitude and humility. And also, the good of what Bill May, who was a Protestant theologian, and later Michael Sandel says, openness to the unbidden. The idea that the opposite of unconditional love, not the opposite, but something in deep tension with unconditional love is a drive to rational mastery and ordering and extraction according to my own priorities and my own goals, right? And this becomes extraordinarily important in the context of parents and children. You don't think of your child as a vessel into which you pour all of your aspirations. You think of a child as a gift. And the appropriate posture towards a child, and not just children are gifts, there are lots of gifts, but I'm thinking of parents and children. The proper posture towards a gift is gratitude, not rational ordering, not rational mastery, not extraction. So the good of solidarity, seeing our deep connections to each other. The good of dignity, the intrinsic equal value of everyone, regardless of their powers or weakness or their burdensomeness or value to the community. Truthfulness, and again, I keeps coming back to this concept of friendship. All these virtues of unacknowledged, acknowledged dependence, of grace, of uncalculated giving and graceful receiving, I think can be understood most richly under the aegis of friendship, properly understood. And so we practice these virtues by those practices that take us outside of ourselves, that draw your gaze up towards others. One paradigm, not the only paradigm, but one paradigm is parenthood, and also what Bella calls communities of memory. Kinds of voluntary associations of people or communities of people who understand that there are goods outside of their own individual goods that need to animate their relationships with others and in that way. And so this becomes, the metric for success or failure in the law of American public bioethics, the areas that I look at, is how well do they build up these networks of uncalculated giving and graceful receiving? How well do they allow us to practice the friendship that is, I think, at the core of human flourishing? And where do they fall short? Do they fall short? And one of the ways in which the legal areas fall short, I think, is in the context of indulging and building doctrines and projecting onto people. And I haven't said anything concrete yet, right? And we can maybe save that for the question period. But I'll give you one very short example, and I'll stop with that. The context of end-of-life decision-making, right? For persons who cannot participate in their own medical decision-making. People who are cognitively incapable of participating in choosing medical pathways and treatments for their own. A mistake that the law makes in some contexts, and you can start with the doctrines and principles and drill down through the normative crust into the foundation and say, they project onto the person in the bed the notion of the unencumbered will. They think of this person, they say, how do I care rightly for this person who can't take care of themselves anymore? And the law indulges presumptions about that individual and the capacities of that individual to do things that are the capacities that are necessary for flourishing under expressive individualism, heightened cognitive capacity to make choices. And you project and say, if that's the person I'm dealing with, and what they need is autonomy, self-determination, that's what I give that person. But a person who can't make decisions has nothing to do with autonomy and self-determination. That's a state of vulnerability, and to build a law and a legal framework, or even legal pathways that privilege certain kinds of legal instruments or whatever, in that direction is a mismatch that ends up not putting us in a position to care rightly for a person who can't care for themselves. That's just one brief, concrete example. The law has to get it right as to who the person is that they're trying to care for, protect, or promote their flourishing. And if the law assumes a person who's unconscious that their highest flourishing is the imposition of their unencumbered will, that's a category mistake. And the principles of the law shouldn't take their bearings from that mistake. They should instead begin with the patient that you have here, not who you wish this patient would be or who the patient was, but instead the patient that is presented to you in that particular clinical moment. Okay? So I've gone on long enough. Thank you so much for your attention. Let's go get some refreshments, and then we can come back and have conversation. Okay, we can go ahead and get started. Yeah, we do this at Notre Dame also. First, it would be great to hear from a student. So if there's a student who has a question or even a comment, you just want to make a short comment, that's fine too. It doesn't have to be a question. So among the students in the room, are you a student? Yeah. Stand up. First of all, this is what we do in law school. You stand up, tell me your name. Aaron Peters, where are you from, Aaron? Where in Oklahoma? Tulsa. I spent a lot of time in Tulsa, actually. Yeah. A lot of Notre Dame families in Tulsa, the Siegfrieds and the Warrens. And where'd you go to high school? Booker T. I know people at Cascia Hall. That's one of the schools. We get kids from Notre Dame to come from. Well, great. Well, welcome. What's your question or comment?
Okay, so I was wondering about the difference between, and you said a law creates atomized individuals, right? Or that's sort of its purpose. What's the difference between an atomized individual and a citizen of like a country?
So what I said was that the assumption of expressive individualism about persons is that the fundamental unit of reality is the atomized individual. Atomized, there's a famous essay by Charles Taylor that I recommend called Atomism. And it's a sort of the radical individuation, the sort of separate, bare, particular unit whose identity is shorn of all connections or constitutive attachments, and is simply taken as the fundamental unit. And you see this a little bit, and it's not the same thing. I don't think Locke and Hobbes are expressive individualism, but they're sort of they're sort of conjectural beginnings of human history, which of course is a Kant essay. They talk about the individual as the primary unit in nature, and then society and community is a secondary artifactual thing, right? Whereas Aristotle, and again, talks about human beings as being naturally social animals, and there's a kind of concept of relationality that's essential to the identity of the person in that framework. And so what I was suggesting is that expressive individualism begins with the proposition that the individual unit of reality is the bare particular self, and that the law built on that presupposition misses fundamental things about lived reality and makes it impossible for the law to genuinely protect us or to promote our flourishing, because it gets a basic question about who and what we are wrong, and then by extension, what we owe to each other. So that was my thesis. And then the question of what is a citizen, that's an interesting, there's of course a legal definition of what a citizen is, and there's a kind of normative definition, I suppose. But that's what I was driving at, yeah. Yes, tell me, stand up. I'm not gonna make everybody, just the students. Tell me your name. Yeah, and where are you from? Vietnam. Okay, great. And you're a student, what year are you? You're a junior. Oh, that's a hard year. Yeah. How's Faraday treating you? Yeah. Okay. Not yet. Just wait.
I guess my question is, so I really admire the virtues of mutual dependence and graceful acceptance, but I think, well, they would be good terms on a social contract.
Mm-hmm.
And they would, I think you set them up to be a good backbone for legislation.
Yeah.
But the way I was hearing or remembering the body section, this needs to be a moral change, a shift in moral paradigm.
Yes.
And I don't know if I'm willing to go there. I'm more inclined to stick with expressive
So expressive individualism works as an accurate descriptor of a human being in a very specific moment for a very specific and privileged class of human beings. My point about the virtues of acknowledged dependence is that those are necessary for creating the conditions, the networks of uncalculated giving, graceful receiving, that are essential for survival and for flourishing by virtue of what we are, embodied beings who depend upon one another. And the freedom of the will, which is something that's important and is not something to be denigrated out of hand, is nevertheless only a very small piece of our identity. And so I don't think bifurcating public and private in that way makes sense, especially if you consider our fellow human beings who are not now and maybe never will be capable of the cognitive activities that are essential for flourishing under the premises of expressive individualism. So any account of human flourishing and identity that doesn't include the elderly, children, and the disabled, certain members of the elderly, then is not an account of human identity and flourishing that I think is true. I think it's, and so I think in the private sphere, you still have people who are utterly dependent upon others, who require care and concern, and won't get it simply through the transactional encounter with people who are helping them for self-interested reasons. Other questions or comments? Yes, stand up. Tell me your name.
I'm Jack.
Hi, Jack. Where are you from?
New Orleans.
Oh, New Orleans. Where'd you go to high school?
Ben Franklin High School.
Oh, okay, good. I have friends that went to Jesuit there. Yeah.
Okay, so I'm thinking about the unencumbered self. This
Mhm.
seems to be a very modern idea. How you trace it back to the early modern philosophers.
Mhm.
And I'm thinking about, it's a sort of irony in the modern way of things that is less embodied than your view. And it seems more reliant on something like the soul or mind,
Mhm.
very independent of the body.
Yep.
And I'm wondering, historically, how that incoherent view, or apparently incoherent, arose out of this increasingly materialist philosophy.
Yeah.
That is immaterial.
No, that's a really good insight, and I'll tell you, one of the currents in modern bioethical thought, especially in the context of neuroscience and neuroethics, is you have a pretty prominent group of mostly scientists, some in conversation with certain kinds of philosophers, making the argument against free will, right? Saying that in fact, by virtue of the fact that the brain, which is a material object, enables the mind through biochemical and electrical processes, it's subject to all of the rules that physical objects are subject to, and also dependent upon past states of the world, so that actually everything is deterministic and there's really no such thing as free will, and free will is a kind of illusion. You have that kind of argument on a collision course with the sort of radical, let's call it libertarian argument that depends on freedom and cognition, right? And in some cases, it's the same kinds of folks that are making the same arguments. So you have a reductive materialism that is on a collision course with an account of the person that depends on freedom and cognition, right? And so that's a problem, right? And it's interesting that you also say, if you made a comment about early modern philosophers and kind of trending towards materialism, and that we end up kind of a reductive mechanism. How is it the case that those folks also kind of birthed this notion of expressive individualism, if Charles Taylor's intellectual genealogy that really starts with Rousseau? I'm sure that's contested. I'm sure there are all kinds of interesting arguments people could make for and against that. All I can say is that it's a really interesting insight, and the part of the book that deals with that is the sort of summary and analysis of Taylor's account. And if you wanted to read more deeply into the literature, you could read The Ethics of Authenticity of Charles Taylor and really get a kind of full-blown sort of arc of where these ideas came from. If that's how ideas work, right? Like, it's not entirely clear that this person had this idea and then so that itself is contested. Yes, sir.
My name is Negus.
Yeah, where are you from?
Maryland. I'm actually in a conference transfer.
Oh, okay. So did you grow up in Annapolis?
I grew up 40 minutes outside of Annapolis, Silver Spring.
Oh, in Silver Spring, sure, yeah, I know Silver Spring very well, yeah.
So I think you sort of like talked about this towards the end of the lecture. But,
Sure.
So does the moment of study or medical policy / practice diminish one's autonomy and make it unethical, like say despite, say, the greater good? And if so,
Could you say that again? I'm not sure I follow what you're saying.
does the moment a study or say medical policy or practice diminish one's autonomy? Does that automatically make it unethical, say despite the greater good? And if so, what are the challenges, I guess specifically in bioethics, that are presented when it comes into deciding when a subject or patient's autonomy is being diminished?
Yeah, I'll start with the second part, and you can give me a couple more sentences on the first part, because I'm not sure I'm fully grasping your question. But so one of the things about this talk is it was a little bit abstract in the sense that it was talking about goods and principles and virtues and habits, and then didn't like so much delve into the concrete medical ethics questions, bioethics questions that I take up in the book. But let's stick with the end of life context, right? I take a long and deep look at Oregon's law concerning assisted suicide. It was the first one, and almost every other law in the country, the other 10 jurisdictions that legalize assisted suicide, almost word for word just copy Oregon's law, the statute, okay? And that, by the way, is sort of a little secret, that's frequently how political branch lawmaking works. You take a model that kind of seems to be working and you just kind of import it into whatever jurisdiction you happen to be in. That happens an awful lot. But then there's an interesting thing, but the flaws that I think are in some cases, in certain quarters discussed in the Oregon law are raised in the conversations in these jurisdictions that sort of take the Oregon law as their new law, and they maintain the law as it exists, including those flaws, which I think implies a kind of normative embrace of the framework, even in spite of concerns about what it might be doing. So the law itself allows for the prescription of a dose of lethal medication to people who ask for it, and then for purposes of self-administering that lethal dose of a barbiturate, usually for the purpose of ending their life, right? And there are certain regulatory provisions of the law that are meant to protect against fraud, abuse, and duress and mistake, and to protect the vulnerable. But the problem is if you read the law and you see how it's being implemented, you realize the deepest problems with a regime of assisted suicide for people who are, so the two normative justifications for assisted suicide that are advanced by supporters of the law are, one, autonomy and self-determination, right? Like the freedom to choose to end your life on your terms as you wish. And then secondly, a kind of notion of compassion, that there is, the purpose of the law is to help relieve suffering in a compassionate way. Those are the good purposes that animate this law. And you look at those purposes and then you look at how it plays out, and even if you take those two as your principal animating goods, there are deep problems with the law because most people who have suicidal ideation suffer from treatable depression, and there's no requirement in the law that these folks get a kind of searching inquiry from experts who know what they're looking for to see if their decision-making is being diminished in that particular way. There's a requirement that the doctor make sure that the person's judgment isn't being impaired, but you see how it plays out. It's a very thin and not an adequate safeguard for people who are suffering under psychic traumas and dispositions that cloud their reasoning, that prevent them from operating at the height of their autonomy, right? That's on the individual level. So that's an example of, so that's a kind of mistake that the law as written and as implemented makes about the population of folks who are going to be making use of that law. It assumes a capacity for autonomy that is in fact, I think, illusory based on the social science evidence. And then you look and you see that the law doesn't require you to assess the competence of the person at the time they self-administer the drug to take their own life. And nor does it require anyone to be present when that moment happens, and not the doctor that prescribes it or any other supervising medical authority. And the average duration between receiving the prescription and taking the medicine is something like 48 days in Oregon. And a lot can happen in a person's mental state in 48 days that diminishes their capacity for free choice and free decision making. And so the law, again, makes a mistake about the capacities of the patients that they're trying to protect and care for. And then you zoom back out from that and you ask the question, well, what about the community itself? Because when you're doing population level, statutory work, that doesn't merely affect a certain community that can make good use of the law, let's say. This is a posit as a proposition, as an assumption of the conversation. We could contest that, and I probably would contest that. But like, take an example like Jerry Brown in California, when he signed the law signed the bill into law legalizing assisted suicide in California, said how grateful he was to have this freedom to be able to go out on his terms. And my immediate thought was, well, yeah, no kidding. Like, you're a rich white guy who has all kinds of privileges, and you're circumstantially protected from a lot of the things that would diminish other people's autonomy in terms of illness or socioeconomic circumstances. There was the people that you have to think about, not just the privileged people who are going to make use of this law, maybe as it's written and as it's contemplated, but people who are going to be subject, who are already beset by the problems of a healthcare system that doesn't provide them with what they need, with an insurance framework that won't pay for what they need, and creates circumstances of coercion that make it impossible for them to make a free and informed decision. And there was this really interesting, and that's another mistake you make about the population, about the personhood of the population, and what their flourishing requires and what their protection requires, based on false assumptions about their capacity for freedom in those circumstances. And so there's a really interesting, 1994, there's this group, this task force that Governor Mario Cuomo put together called the New York Task Force on Life and Law. And I'm actually going to read you what they wrote. It's I think pretty potent, right? They were almost to a person, I think, in favor of the ethical proposition that people should have the freedom to take their own life if they wished. They studied the question against the backdrop of the issues of public health, mental health, problems of undiagnosed mental illness, problems of badly managed pain, right? And said, if you inject into this system the freedom of assisted suicide, you're going to create risks to these vulnerable populations that have never been as severe as they would be. And these are people, the members of this committee would all identify themselves as liberal or progressive ideologically. And again, afterwards they said, we think in the abstract that assisted suicide is a right that people should have. But they unanimously concluded that the state should not legalize assisted suicide because of the following. We believe, this is the committee talking, we believe that the practices of assisted suicide and euthanasia would be profoundly dangerous for large segments of the population, especially in light of the widespread failure of American medicine to treat pain adequately or to diagnose and treat depression in many cases. The risks would extend to all individuals who are ill. They would be most severe for those whose autonomy and well-being are already compromised by poverty, lack of access to good medical care, or membership in a stigmatized social group. The risks of legalizing assisted suicide and euthanasia for these individuals in a healthcare system and society that cannot effectively protect against the impact of inadequate resources and ingrained social disadvantage are likely to be extraordinary. So I think the New York Task Force, in making the recommendation, were very sophisticated and nuanced in thinking about the human reality of the people of New York that would be adversely affected by a law like this, when on its face it looked like just a maximization of freedom. But they understood that these folks, their flourishing didn't depend, they didn't need more freedom of this kind in order to flourish. They needed some kind of systems of protection, which could sound paternalistic and probably is paternalistic, but sometimes paternalism is a good thing, in my view. So one other thing that got my attention when I was looking at this. So the percentage of people who have suicidal ideation that are suffering from treatable mental illness is like over 90%. The percentage of people who got psych consultations, who sought the medicine to end their own lives, was like 2%. Okay? there's like and drill down more deeply, people suffering from cancer experience clinical depression at a rate much higher than the general population. They also, and their depression, an artifact of their depression is the view that they are a burden to others, which in many cases is not true, and their family doesn't regard them as a burden. And so that's significant. That's a huge percentage of the population in Oregon that are seeking assisted suicide, and there are some years in which there were no psychological consultations at all. So that tells you that there's something wrong. Now, this data that I'm referring to, by the way, is very scarce and hard to access because there's not enough funding in Oregon to audit and to keep track of these things. So there's not a lot that we know about what's going on, but we do know that, and that to me is arresting, and even in the context of the people that in Oregon and other states that are dependent upon welfare or dependent upon public forms of insurance like Medicaid is a very high percentage. And in those instances which insurance covers it, insurance will cover self-administration of a lethal drug, but they have caps, hard caps, on the kinds of treatments that might alleviate the suffering that these folks are experiencing. And then here's the last thing I'll say. They've rated different states on their utilization of hospice and how good they are at hospice. And Oregon, and this is a pattern that appears to hold for those jurisdictions that legalize assisted suicide. Once they legalize assisted suicide, their utilization of hospice and the excellence with which they utilize hospice drops precipitously because a path of least resistance becomes assisted suicide, not palliation and hospice treatment. Yes?
You said in the first of your lecture that expressive individualism is a good thing. It should be preserved. And I'm wondering why people who are capable of autonomy should subject themselves to a legal framework that benefits other people and they might conceivably harm them.
Is there a particular thing you have in mind, system?
Just, in other words, you make a very strong case
Yeah.
that there are many victims
Yeah.
of pleading for assisted suicide.
Yeah.
That there are also victims of the prohibition.
Right, of course. Yeah.
Why should the people who are lucky enough
Yeah.
to be capable of autonomy,
Yeah.
why should they practice the virtues that you recommend?
That's a great question. I think so. You'd have to have. So the question is, why shouldn't the privileged few who can live expressive individualism, at least for the period of time when they can, be free to do that? And why should their freedom be impinged upon by a legal structure that is designed to protect people who'd be endangered by the kind of freedom that would be beneficial to that narrower group? And then it depends on how you understand justice, right? I mean, it depends on how you understand. It's a political theoretical question that you're raising, and all I can do is respond with what I think is the most just and humane framework, which is to say that if I'm a lawmaker and at a population level, I would be disinclined. It would seem to me inhumane and unjust to serve the most privileged at the risks and peril to the weakest and most vulnerable. Now, people could disagree with that, and that's what the political debate would look like, right? And in this book, I make a point in the book to say that this is not meant, again, as apodictic philosophic proof. I'm not trying to prove a philosophical proposition. What I'm doing is trying to make a proposal, sort of rooted in friendship, that people should consider and think about and compare to their own lived experience and their own understanding of the arc of their life as humanly lived, and the sort of falsehood, in my view, of expressive individualism as a comprehensive account of a human life from birth to death, or even before that. And all I can do is make that proposal, and if folks are convinced that it's better to enable the powerful and the privileged to work their will at the risk to the weak and the vulnerable, that's a position. We see that in Plato's Republic, right? I mean, we see that in Thucydides. I think that's not a persuasive argument, but in our system of government, we just have to have that conversation and see what happens. Yes.
Hi, my name is Nitin Kulkarni. I'm a parent of Johnny.
All right.
Junior here. So one observation and a practical question about the implementation.
Sure.
So, it's interesting you brought up the Republic. I was going to ask a question about that, the second part. So when you mentioned the expressive individualism, it seems to me like you're setting up a straw man argument, because that concept cannot be applied to a newborn or someone who is invalid. And so usually it's applied to someone who has a full
Yeah.
functioning faculty. And so when you set it up like that, it seems like, of course, it cannot apply to these two extreme ends. Therefore, it's an invalid concept, and that kind of didn't resonate with me. The other part about the expressive individualism is the concept being divorced from the whole value pursuit. Meaning, if you believe in expressive individualism, you'll have to believe in a certain different paradigm to be able to help your parents who are maybe in a wheelchair, or in a different paradigm if you're going to be a good parent. And with expressive individualism, in the way you define it, but individualism, the way I'm looking at it, can also be combined with a pursuit of values, where you are a parent because you value
Sure.
that role and value what your kids are going to grow up into, or what your parents gave you, and so there's not much of a opposition to that, to those two ideas. And the practical question I had was about the network of mutual dependence. And there I thought maybe a philosopher king is going to step in and say, I will tell you what your network of mutual dependence is going to be, and what you owe to society.
Yeah.
Instead of being decided at a private level, we already had a practical implementation of that. I grew up in socialism in India, and Russia was close by. So we saw how the Politburo or some chosen members can decide. We will let you know what your circuit of the network of mutual dependence is. So that became a little bothersome. If we could clarify those two issues.
That's great. So I'll start with the last one. This book is about American public bioethics, and the arguments that are made presuppose a system of deliberative democracy, where we try to convince each other as to how we should live, and try to and what the normative foundations for our legal proposition should be. So if we're a deliberative body, state legislature, Congress, operating according to your appropriately authorized powers, what I'm basically arguing for is having a conversation that digs into the question of, okay, someone says, I think we should have this policy. Someone says, I think we should have this policy, or this legal proposition, or this regulation, or this ordinance. I'm arguing for a conversation about, okay, the rule that you're proposing, I mean, the assisted suicide law in Oregon's legislature should have had a conversation about, let's talk about vulnerable communities and those who will not be cared for by the individual or aggregated private choices of individuals who pursue the values that they're pursuing, right? Like if a parent abandons their child, I think there is a role for government to maybe facilitate other private action, right? Like it doesn't presuppose any top-down totalizing government at all, this argument that I'm making. But my argument is that there are some people who are entitled to care irrespective of whether or not their care is part of someone's own subjective life plan as they see it. But the solution to that problem, let's take a parent who doesn't want to take care of their child, the solution doesn't mean that the government comes in and does it. It doesn't have to mean that. It could mean that the government provides certain kinds of incentives and frameworks that will result in people sort of directing their choices in ways and direct private ordering in ways that lead people to the construction of these safeguards. But in an optimal way, people, I'm arguing, this is a normative proposition. People, what they should do, and people are at the height of their flourishing, and they are most human when they're caring for other people. When we're taking care of each other, that's when we're at our most human. And a rejoinder to that in the public square that might very well command a majority of votes, in which case you just got to keep trying to convince people, is that like, no, I don't want to do that. I don't want to do that. I don't want to be made to be friends with my neighbors. I don't want to be made to care for my children. Judith Jarvis Thompson makes this argument explicitly in her essay in defense of abortion. very explicitly. So it's not a straw man. These are arguments that are incipient and in some place explicitly stated in the philosophical literature and the laws that are built on top of it. And in a democracy, in a flourishing polity, people make the arguments. We have this argument. I say, I think we should have laws that facilitate, promote the structures of uncalculated giving and graceful receiving that support the weakest and most vulnerable among us. And somebody else says, that's good that you think that. I would rather develop the fruits of my labors and live as I wish to, and if I want to help somebody, I'll help them. If I don't want to, I don't want to, right? And that's just another position in the public square. And we'd have that argument. Like, it doesn't mean that, but I do think there's a role for government, though, when there is a person who, because of disability, we'll take the disabled, a disabled child is abandoned by his or her parents. I think, and the private ordering is not sufficient, and no one is stepping up to do something. They don't make an adoption plan. They don't do some other kind of private ordering that takes care of the needs of that child. Then I think the government does have to step in and say, we're going to take care of those people who can't take care of themselves. And is that a more robust role for government than some sort of folks that are more devoted to a kind of free market or libertarian ideology? Yeah, it is. But that's the argument that we're going to have, and then we vote, and whoever persuades a majority of their colleagues prevails. Yes, sir.
That may be the answer to my question, because I've been thinking, by the way, I'm Joe Ross, I'm here with Johnny.
All right, where are you from?
Originally New York, then California, now Ohio.
It's a lot of different places.
Military.
Oh, okay.
So, I think the expressive individual is obviously human, necessarily so.
Sure.
A body of mutual defense, an embodiment that is dependent on other embodiments, raises the question of what makes that human, and where you draw the line. If you want to bring normative conclusions out of who we want to have empathy with, and I guess to some of those bioethics issues, like what do we define as the body that we care about, that we empathize with? And I guess your answer may be that's something for the politic to decide, right?
Well, okay, so.
Do we want to care about a dog as much as we care about a human?
Okay, now what you're saying. So the question, it's a kind of boundaries question that you're asking. The boundaries of the moral and legal community. And I think, and my sequel to this book is about different boundary questions involving animal-human chimeras and hybrids, as well as synthetic embryos, and finally, the hardest case, cerebral organoids, the creation of structurally and functionally, apparently online brains that are not part of a larger body. Like, what do you do? Like, what are these things? You know what I mean? And I'm working on that. But I do think the fundamental question is, who are we, and what does it mean for us to care for or not care for another being, right? And it's not limited to fellow human beings. It includes animals. It includes the environment. There's all kinds of implications for this. And I think, so I just wrote an amicus brief in the Supreme Court supporting California and its right to exclude from its local markets pork that has been produced through what I regard as gravely inhumane practices, right? Like these gestational crates that I find to be problematic, put it that way. And there's a dormant commerce clause question. So there's like a law question, but then the question is, the US government said that there's no legitimate local interest in California in excluding this from the marketplace. And so what we did in our brief was to try to sketch out the sort of philosophical tradition of stewardship and protecting animals from cruelty. And it wasn't about, and at no point did we say that animal is a person or that the pig is a person. We just said that our relationship to that and how we treat those animals has implications for our own self-understanding and our own, and whether we diminish ourselves or whether we actually honor what we are and should be. And you see that a lot. You see that a lot in virtue ethics. It's a kind of virtue ethics argument. So I think sometimes I think the boundary questions are the wrong question, Because, and I think that philosophical efforts to define personhood are almost always made in a way with a very specific goal in mind, which is kind of to exclude a certain subset from the circle of personhood, whether it's great apes or even people with dementia or, whatever. There's sort of pre-personal, post-personal human beings. Like, so you have the class of human beings, and then within that you have persons who are entitled to moral concern and protection of the law. And I've been unsatisfied by the philosophical arguments trying to make the case for that delineation. It just doesn't seem like special pleading or self-interested ways of the strong dividing the world up in a way to intentionally exclude the weak. And so I think the philosophical literature on personhood has led me in a different direction to sort of ask questions about what does it mean for me to treat this other in a particular way. And that may sound abstract, but I think that's kind of where I'm going. Ben.
Professor.
Hi.
Hi. I'm from Santa Fe.
I know you, Ben.
My question is about applying the anthropology that you argue for.
Mhm.
And the Oregon assisted suicide statute comes to mind. And your critique of that, as I heard it, was it doesn't actually implement autonomy very well, because people's autonomy in those situations is compromised, and it's not what what the model that we imagine it to be. If someone were a legislator in Oregon faced with that statute, and who took your argument about expressive individualism is not the reality of people I represent, there's the weak, there's this web of dependence. The assisted suicide question is a little bit more complicated, or maybe difficult than someone who might want to be cared for. If the people in question are going to be allowed to say, I don't want to be cared for by my neighbors. So how would somebody with the anthropology that you suggest think about that statute and apply that anthropology to it?
Could you give me one more sentence on that? You said, so I was following you right up until the question. So I thought it was.
Yeah, I guess my question is about how do you get from the reality of what persons are, vulnerable, all different states, to the question of what to do, to the question of a norm. Should we pass this statute?
I see. Yeah.
How do you apply that anthropology?
So, okay, tell me if I'm not following you. So stand up, keep standing. So what I hear you saying, Ben, so Ben and I met in 1998, I think. Was it 98?
Like that.
Were you clerking in 98?
It was actually, I was, but it was 2001 when we met. It was when you were clerking.
No, I clerked in 99, 2000.
Well, then it was...
So you interviewed me for my clerkship down the street. Ben was a Notre Dame Law alum, editor-in-chief of Law Review, and a lovely person, lovely family. So that's neither here nor there. But the point is that you're asking, how do you operationalize legal propositions from an anthropological set of norms? Is that what you're asking?
That's what I'm asking.
Okay. So I would say this. I would say that, let me take an example. So I think that there are prudential arguments against assisted suicide laws that I basically have been making, right? Those are prudential arguments, not in principle. There are in principle arguments against assisted suicide, which I don't talk about so much in the book, that I think are persuasive. But about the good of what medicine is and the ends of medicine and so on. But and it tracks very close with what the AMA says about assisted suicide. They oppose it and so on, for not for prudential reasons, but for principled reasons about what medicine is and what the good of the art of medicine, the animating good of the art of medicine as a profession is. We're not going to talk about that. But if I'm in Oregon, I'll put it this way, and I'm the legislator. We're debating this bill. Should we have an assisted suicide bill? I stand up and I say, I don't think that we should pass this law because it fundamentally misunderstands the needs of our polity, of our constituents, because it fundamentally misunderstands what and who they are. And it projects onto them a false narrative of autonomy and self-determination and presupposing certain kinds of capacities that are just not true under these, for most people. bracketing a sliver of very privileged people who might very well be able to, at free and flourishing autonomy, say, I want to kill myself, and then those people can do that, right? The fallout, the collateral damage of the weakest and most vulnerable, the disabled, members of stigmatized minorities, the elderly, et cetera, we can't do that. We can't pass a law that benefits this sliver of the privilege at the risk of everybody else. And I would say that the fundamental problem with the proposed statute is that it makes a category mistake about the nature of the people that we're trying to serve. That's how I would operationalize that. And there's a different context too. So in the same chapter, I talk about end-of-life decision-making for people who are not competent to make decisions for themselves. Their competence has been extinguished, maybe never existed by some kind of cognitive impairment, right? And how do we think about the common law right to refuse unwanted medical treatment, including life-sustaining measures, which is a feature of every single, so assisted suicide is only legal in like 10 jurisdictions in the United States-ish. But every jurisdiction in the United States, every single person of sound mind has the freedom under the common law, and maybe there's a protected liberty interest on the Constitution, not clear, but to decline unwanted medical care. And that includes life-sustaining measures, to discontinue or to refuse in the first instance life-sustaining measures. And I don't deal with the category of people who are competent, who can weigh costs and benefits and think about their lives and make that decision, because they're all different kinds of motivations one might invoke to refuse unwanted life-sustaining medical care. It could be that the intervention itself is unduly burdensome or futile in some way, or that it will impair your presence to the rest of your family, or it'll bankrupt your family. You're not choosing to hasten your own death. You're not embracing your own death. You're saying, I'm saying no to this intervention with the understanding, the foreseeable consequence, regrettable foreseeable consequence, that my life's going to be shorter now. But I'm not choosing death, right? That's a different structure of intention. Then you might say, I'm turning down this antibiotic because I have pneumonia, because I'm tired of life. I get pneumonia, I'm healthy otherwise. No, I don't want antibiotics. I want pneumonia to take me, and so I refuse that unwanted medical care. That's a different kind of intention. I don't really deal with those questions. I deal with the people who cannot speak for themselves. And what the President's Council on Bioethics came up with, which I think is true to the anthropological reality of a person who is unconscious and totally dependent on other people, that categories of self-determination and autonomy don't make sense in that context. Because you're making a mistake about what and who this person is in their current state. And so instead what you should do is you should certainly try to discern what their wishes are, because that's part of human flourishing, if they're discernible. But really what this is like a very practical thing. They endorsed a medical power of attorney where you appoint someone as a proxy to act considering your wishes, but also considering the patient that you now are and what are in your best interest, and making a judgment accordingly, focusing on the intervention, not on underlying quality of life, because that creates a temptation that's too strong to project your own sense of what you would do in that situation. And we're very bad, social science confirms this, at understanding and inhabiting other people's situations and being able to understand when they find meaning and value in a diminished physical condition. We're bad at projecting our own capacity to understand how we would react. We're even worse at trying to judge others. And the risk is we try to hold a diminished person up to a quality of life standard that they can't meet, that we think is the standard between livability and not worth living anymore. And it frequently doesn't actually comport with what they think. And so the council said, focus on the intervention. Ask, is this intervention unduly burdensome? Pain is an obvious burden. Expense could be a burden. I mean, you have to really think and unpack the concept of burdensomeness. Or is it futile? Does it not achieve its proximate end? And if either one of those things is true, then a person is ethically permitted to discontinue life-sustaining measures. If not, then you should err on continued care. That's what the President's Council on Bioethics said, and it was rooted in a kind of understanding of the imperative to always care for the patient who presents herself to you as she is now, not as she was, not as you wish her to be. And there's this really, and I'm sorry to keep talking, but this is a really interesting short story about a woman named Margot who, at the height of her, she knew that she had Alzheimer's in her family and had a heritable disposition to Alzheimer's, and thought, if I ever get Alzheimer's and I ever suffer from dementia, I don't want any medical care at all that will sustain my life. And sure enough, she gets Alzheimer's, she suffers from dementia that doesn't prevent her from apparently finding joy and value in her life. She doesn't recognize people, she listens to the same song over and over again, she draws pictures, and then she gets pneumonia, and she says, I don't feel good, can you give me something to make me better? And the question is, what do you do? What do you do? And Ronald Dworkin says it's an impermissible paternalism to give her antibiotics. You have to honor the free and flourishing choice of who she was when she had the capacity to choose, not what this diminished person wants and is expressing that she wants to you right now. And Rebecca Dresser says that's a category mistake.
You don't get to change your mind.
Right. It's called pre-commitment in the law. Yeah. Yeah.
Apparently the people between the Golden Gate Bridge and the water mostly change their mind.
They sure do. Aaron Cariotti says that. Okay, more questions. Yes, sir. Tell me your name.
Paul sat in GI class in 95.
Ah.
And apparently, and that was GI class in 22.
Great.
I'm just dying of curiosity to hear your opinion on abortion.
Okay. What about it?
The right for a woman to choose her health care and have their doctor increase or whatever.
Yeah.
Versus the right of the birth of the child. To carry the child to term as a forced issue by the state in context of the general good of humanity.
Yeah.
In the sense that we do have an overpopulation problem on the planet. So it's a big question. I'm opening a can of worms, but
No, sure.
I mean, I really enjoyed your presentation, and I get what you're saying about how we make laws. And I am active. In the biotech industry, and
Where do you live?
here in Santa Fe.
Okay.
Yeah, and I also do a lot of work on the state level, at the government around us. But I'm really curious to just understand how you view the issue of abortion, and especially with the upcoming midterms and the context that it's a hot political issue right now.
Yeah. No, it for sure is, and my first of all, my kind of commitment to discourse, which I think I learned at St. John's, and is that everybody in the debate is defending something that they regard as essential and vital, and as fellow members of the community, we have to be empathetic, and we have to be. And the greatest gift of the St. John's education is kind of learning how to listen and how to kind of understand. And the first thing you got to do is to understand the argument that the person on the other side of the question is making, and understand it in a way that tries to inhabit their perspective and tries to do it in a way that's empathetic and loving, right? And that's hard to do when you're talking about things that are unbelievably controversial and implicate fundamental goods that are extremely important to folks, rightly so. The abortion question is very complicated. There's a legal dimension to it. There's a constitutional dimension to it. There's an ethical dimension to it. There's a biological dimension to it. So it's hard to, if you wanted to, I would take a long time to explain what I think about that question as an ethical matter and how to operationalize those normative propositions in a legal way. Which part of government has the institutional competence to do that? It really implicates even questions about what law is and how it works, and interpretive questions. If you want to get into the constitutional issue, like what is a constitution? How do you interpret a constitution? What is the role of the judge? What are the role of the political branches? And in the recent case, the Dobbs case and these other cases, you could describe that dispute as fundamentally a question about what law is and how to read the Constitution and what the best way to interpret these provisions are and how to apply them. And then there are, of course, questions about stare decisis, which is a prudential doctrine and common law jurisdictions that, that depend on precedent. So it's so many things. And one of the reasons I didn't talk about it was not just because it's controversial, but because it would take hours and hours and hours to even explain the jurisprudence of abortion in American law. I have like a 75-minute set-piece lecture. I mean, the longest chapter in the book is a chapter on abortion, right? And it's 75 pages long. And it doesn't even talk about Dobbs, because the case came out before Dobbs. And the book itself is only, what? It's like 275 pages. So it's a very hard question. And here's what I'll do in answering your question. And one of the problems with the debate over abortion in America, and this is something that Johnnies are especially situated to fix, is when you're describing the competing goods at issue, you have to describe them in a way that is fair to your interlocutor, right? You can't recast what their position is in a manner that advances your own position. You have to do it, your argument has to put your opponent's argument, if the opponent's even the right word, in the very strongest form, even a stronger form that maybe they're capable of making themselves. You have to steelman that argument before you engage with it. And then you have to also be prepared for the possibility that at the end of the day, people are not going to be persuaded sometimes. And they're going to continue to hold, and that's how it works. And I'll tell you something. One key to, if you're an observer of the debate, and you're trying to figure out what you don't know what you think, it's complicated, it's perfectly natural not to know what you think about abortion. Abortion is an ugly topic to think about for a variety of reasons, and most normal people don't spend their time thinking about it. I spend a lot of time thinking about it and writing about it, so I'm not normal. But one heuristic or tool you can use is to say, between the two interlocutors, which is a person defending an argument that they it's sort of a cui bono thing, right? Like, I mean, everybody in this room probably knows that my view is that every human being, from conception to death, is intrinsically equally valuable, and any of the arguments that try to draw lines of personhood between those who count and those who don't count, based on criteria that are established by the powerful and the privileged, for the sake of excluding that group, are unpersuasive. And so there are two arguments for abortion. There's the personhood argument, and there is the bodily dependence argument. And I go over all this in the book, and I go through the philosophical literature, and I go through how it's operationalized in the law. And that's what and so the personhood argument is not every human being is a person, and only those individual human beings who are capable of actualizing right now the capacities that I prioritize as being worthy of meeting the standard of personhood are persons, and those who cannot are not, and they don't deserve the protection of the law or moral concern to the same extent. And interestingly, that argument, when applied in a neutral way across classifications of individual human beings, cuts a lot farther than a lot of people are comfortable with. Because what that doesn't just exclude the unborn, it excludes newborns, it excludes, Peter Singer himself has got an extraordinary capacity for consistency. He's like, yeah, no, of course. And the same thing is true of the philosophers that I take up, Marianne Warren and Boonin and others, who say, and when they end up having to say, if your theory for abortion rights is personhood, you have to also accept the proposition of infanticide, because it's inconsistent not to. But then what comes in next is what's called the bodily dependence argument, and Judith Jarvis Thompson is the most famous proponent of this proposition, that a living being does not have the right to your bodily resources unless you freely grant consent to the use of your body. And she uses the violinist example. The person's abducted and a violinist is hooked up to her kidneys, and they say, well, this person's going to be connected to you for 9 months, and that's going to be, and we can't unplug him because that would cause his death, and sorry that this is a burden to you. And the bodily dependence argument focuses on the burdens, which are real burdens of an unwanted pregnancy, And then they also usually include the burdens of unwanted parenthood as well, as burdens in the calculus of evaluating what the right should or shouldn't be. And Thompson, and I think Harry Blackman's opinion in Roe v. Wade, makes the same mistake. It describes the context of abortion as a clash between two strangers, one of whom is a person, one of whom is something less than a person, over the scarce resources that properly belong to the first person, namely the woman. And that, to me, is a kind, once you frame it that way, as a legal matter, as an ethical matter, it doesn't surprise me that the next proposition is, okay, who gets the right to lethal force to repel the intruder? Right? I say that's not a human way of framing the reality of the parent-child relationship. They're not strangers. They are related to each other. The unborn child in the womb is inarguably, as a matter of biological classification, you know this from Driesch and Spemann and Roux and all the first-year biology, it's a living organism, member of the species Homo sapiens, that directs itself along a species-specific trajectory of development, requiring an environment, a hospitable environment, as we all do, to survive and flourish. And so you have a human being in the womb who is biologically related, and then also related in the bonds of kinship that stretch backwards and forwards and sideways. And so I would describe the human context in which the question of abortion arises as a sometimes tragic conflict, or sometimes tragic crisis involving a mother and her child. And the reaction to that is not to say who gets to use lethal violence against the other one. The reaction is any decent society would say, we have to rush to the aid of these people. And the law has in it mechanisms to deal with conflicts that sometimes can only be resolved in which the death of one is a foreseeable but unintended consequence. Right? We have principles of self-defense and necessity and justification in the criminal law that would be interesting to apply in this context. It involves concepts of unjust aggressors. It involves it involves questions of relationship. My view is that the way I would approach the question ethically is to say you have two human beings who are locked in are integrated in a way that you don't see in any other human relationship. And our job is to care for both of them as best we can. And if there are circumstances in which continuing a pregnancy threatens the life of a woman, then we're in the domain of necessity and excuse and justification, and we may have to look to those kinds of concepts to figure out how to build the law. But the thing that I find defective in our public discourse is that one side only argues about burdens on women, which are real and serious, and people like me have to take those seriously and have to devote ourselves to alleviating those burdens, right? And I'm actually doing that at Notre Dame. We've got this project called Women and Children First, which is a giant interdisciplinary effort to try to figure out healthcare, housing, poverty issues, addiction issues, race issues across the board to care for moms and babies and families in the best way that we possibly can. That's my reaction to that situation. But you have one side arguing that focuses on one side of the equation, just the burdens, and then they say things like potential life, or they don't describe the other good at stake. And then you have the other side that says that only focuses on the good of the life of the unborn child and doesn't take seriously enough the genuine burdens on women, especially poor women, women of color, and issues that you have to grapple with there. Health issues, but not just health issues, right? Psychic, familial, economic burdens. A real conversation requires us to admit in the fullest form the contending goods that we're grappling with. We have to acknowledge in an honest and forthright way the burdens on women in this kind of a setting. We have to acknowledge also in a forthright way that the other good, the competing good, is the life of a living individual member of the species Homo sapiens who is the child, biological offspring, as a matter of classification, of the woman, the mother, at issue. And I'll just conclude, and I'm not going to answer the question, how do you do that? And I think, by the way, the place to debate that is the public square and the political branches, and I don't think that projecting onto a federal constitution or a state constitution a rule that solves that problem when that's not present in the document itself, text, history, tradition, or even plain meaning, is a way to solve it. I think it's best solved the way every other country in the world solves this problem, by the way, through the deliberative democratic process. We were, up until this summer, one of the only countries in the world where an unelected branch of the judiciary resolved this question. Other countries debate it, discuss it, pass laws, and they're provisional, and they continue to try to persuade each other, and they're not as pressurized and polarized as we are on these questions for a variety of reasons. But the fact that they actually get to talk to each other about it, and right now it's messy talking to each other. And people have had 50 years of not talking to each other about it, and now we have to, because we have to govern ourselves on these questions, and that's going to be hard. But here's what I'll conclude with. Every day I wish I was wrong about what I think about the question of abortion. Every day I wish that I was mistaken about what I take to be the moral status of the unborn child and what abortion is and what it does. Because if I didn't believe that, I would be a much happier person who would sleep better and could focus on other things. And so every time I debate this question, every time I read about this question, in a way, I'm kind of wishing to be persuaded away from the position that I hold. But I have not found those arguments, and I don't find them persuasive. And as it is a deeply, in some cases tragic, conflict of goods involving a mother and a child. And we as a society have to come to their aid and figure out how to care rightly for both of them. And that actually doesn't settle the question of what the law of abortion should be. Because there are circumstances, fact-bound circumstances, in which we have to ask hard questions about how those goods stand in relation to each other. So that's what I'll say about abortion. All right, let's see. I think we have time for one more question. Yes, sir. Are you a student?
Yes, sir.
Perfect. What's your name?
My name is Holland Rado. I'm a sophomore from Austin, Texas.
From Austin, Texas. I was just in Austin, Texas. It was a great place.
So I wanted to ask, earlier you had a slide, and you talked about this a little bit, this sort of intellectual range, you could say, of expressive individuals.
Mm-hmm.
From Locke to Rousseau to Spinoza and so on and so forth.
Yeah.
Many of these writers that you mentioned have been very, very influential in American government, especially in American economics.
Yep.
We only look at Locke and his influence on Jefferson, for example. To what extent do you think that expressive individualism is built into American law as it stands now, and as it began with the founding? And do you think that if it is built in, that this is an issue, perhaps a hindrance to your vision?
So my friend Pat Deneen spoke at the Annapolis campus very recently, and Pat's view, he's my colleague at Notre Dame, his view is that it's poisoned from the founding, and he doesn't use the word expressive, he uses the word liberalism, and he's like the failure of liberalism, and I'm not sure well, I won't say that, but the point is that I'm not persuaded, and I'd need to know, I'm not persuaded that Locke and Hobbes, I'll put it this way, I agree with Robert Bella that Locke and Hobbes and Adam Smith were not expressive individualists. They were kind of individualists with, as part of their conjectural understanding of the beginnings of what society is and social contract theory. But I also think that Locke had an interesting theory of personhood that involved memory and understanding yourself as a source of continuing ideas and self-understanding. But that's not what we're talking about. I think so. I think it's an inadequate moniker that Bella applies to Locke and Hobbes. He calls it utilitarian individualism. I think it's not utilitarian in the sense of the philosophical tradition of utilitarian. What he just means is it's an individualistic theory or hypothesis meant to serve the proposition that, in Locke's case, that if you conceive of the individual and then society as the second order construct, and everybody's kind of pursuing their own self-interest, and Smith too, in a well-regulated system of laws, respecting the natural liberty of others, then everything works out well, right? It's for the purpose of the well-functioning of the polity. It's not for the assertion of the unencumbered will and the authenticity that comes from inside. Rousseau is different from them in that way, I think. It's this sort of self-giving lawgiver, which then comes up in Kant, right, in the grounding of metaphysics and morals. And Hobbes, so Locke wants to entertain a theory of individualism for the sake of greater goods. Hobbes wants to entertain a proposition of individualism because of, in service of sort of lower fears about a war of all against all, and requiring a kind of totalizing state that is the only thing that can protect you. You sort of give your freedom to that, and it can protect you from, and I'm obviously oversimplifying, but like you can protect you. I don't think that's expressive individualism. I think that's a kind of individual. I think expressive individualism is more about the interior turning, the interrogation of the self to find authentic, individual truths that you then express and then configure your life plan accordingly. That's not, I don't think, and again, I could be wrong, I don't know enough, I don't know as much about Locke and Hobbes as Patrick does, but my sense is that they're doing something different from that. And I'm persuaded by Taylor's genealogy, and if you read the Ethics of Authenticity, you can find all of his account there, beginning with Rousseau's l'assentiment d'existence and the inner voice that's definitive, and his concept of freedom, which is not the same thing as the inner voice of nature, but certainly relates to it and augments it in the way it's operationalized in his philosophy later and picked up. And then you get these interesting romantic poets and literary figures who are talking about sort of transgressive ways of living your authenticity in the communities that are repressive and condemning, those roles and structures. And, Bella talks about expressive individualism being a kind of reaction. And again, I'm not sure this is how ideas work, but like his thought was it's a kind of reaction to the stultifying, ironclad roles that people had to be locked into, and the Protestant Reformation plays a role. And it's an interesting kind of idea. It's a sort of reaction to a stultifying sort of collectivism almost defined by specific sorts of roles. And that's where you see the emergence of this. And in the Romantic literary movement, I think there was some agreement about the sort of the concept of nature for them is different than it is in the sexual revolution, and nature being entirely subjective, right? So that's a kind of long-winded way of saying I don't think that Locke and Hobbes and Smith are expressive individualists, and there may be other problems with them, and Patrick Deneen would certainly say that there are, but I think our method, our kind of apparatus of deliberative democracy is robust enough that we can actually have a conversation about human identity and flourishing as a precursor to building structures of laws and doctrines on top of it that are meant to protect people and to promote their well-being. So, thank you guys so much for coming. Great to see you.